A single misplaced sentence during a traffic stop while you're armed could transform you from a legal carrier into someone facing criminal charges, even when you thought every action was lawful. I'm revealing the 4 precise phrases that might prevent arrest, legal battles, or permanent loss of firearm privileges. When this video ends, you'll possess an exact verbal blueprint, keeping you protected and compliant throughout any law enforcement interaction. Currently, armed citizens face arrest during standard traffic encounters because they're unaware of proper phrasing, or even worse, they volunteer excessive information. Within the previous 12 months, numerous lawful carriers found themselves before judges due to brief moments of incorrect language. This affects responsible firearms owners exactly like yourself, and I'm ensuring it won't affect you. Phrase 1. I don't know, officer. Your initial crucial statement arrives the instant law enforcement asks, "Are you aware of the reason for this traffic stop?" This represents entrapment questioning intended to extract guilt admissions before they've disclosed your alleged violation. Whether involving velocity violations, incomplete stops, or mobile device contact, they're seeking your confession. Here's where most armed individuals make errors. They begin explaining, rationalizing, or confessing. I exceeded the limit slightly. Perhaps I didn't fully stop. I was simply verifying my navigation. Each statement becomes an admission usable against you during legal proceedings. And it definitely will be. Within traffic regulations across all jurisdictions, your statements become documented evidence in the officer's incident report. That documentation becomes courtroom evidence when challenging citations or when the encounter intensifies. When you're carrying concealed and this situation deteriorates, your own language becomes prosecution evidence. I've witnessed permits canceled because encounters escalated after someone spoke excessively. A single incorrect statement, particularly when anxious about your weapon, can escalate a minor traffic fine into a massive legal expense. Within certain jurisdictions, when you're armed and the officer determines you're uncooperative or questionable based on rambling responses, they possess authority to prolong the stop, inspect your vehicle, or even place you under arrest upon discovering any technical infractions. Therefore, here's your initial phrase, exactly as stated. I don't know, officer. Alternatively, simply, no, officer. That's everything. Nothing additional. Don't elaborate. Don't speculate. Don't offer information. This answer remains respectful, non-confrontational, and provides zero evidence. You're neither impolite nor difficult. You're merely avoiding self-incrimination. However, here's where individuals fail during the second interaction portion, and it's significantly more hazardous for armed civilians. Phrase 2. My license is inside my wallet. I'm retrieving it presently. Your second crucial statement occurs when law enforcement requests license and vehicle registration. This moment causes concealed carriers tremendous difficulty, and I've observed it conclude in arrests repeatedly. The error: moving without verbal narration. Visualize this scenario. You're carrying concealed. The officer requests documentation. You reach toward your storage compartment or rear pocket silently. During that instant, the officer cannot determine whether you're accessing paperwork or accessing a weapon. Even possessing valid authorization, one suspicious movement can convert a traffic encounter into a high-risk stop with drawn firearms. According to Fourth Amendment protections, officers can defend searches and arrests, citing suspicious movements. When you reach without explanation, and the officer alleges questionable motion, they possess authority to order your exit, conduct pat-downs, search the vehicle, and arrest you upon finding any technical errors. Should they discover you're armed and can argue you created perceived threats, you might face charges ranging from disorderly behavior to weapon brandishing. Within mandatory disclosure jurisdictions, neglecting notification while making abrupt movements can eliminate your authorization. I've observed lawful carriers charged with serious threatening offenses because they accessed a wallet too rapidly. Therefore, here's your second phrase: absolutely required. Before moving anything, state, affirmative, officer. My license is inside my wallet within my rear pocket. I'm accessing it presently. Then move deliberately. When requiring the registration, state, my registration is within the storage compartment. I'll retrieve that next for you. Then reach. Every movement receives announcement. This eliminates any suspicious movement allegations and demonstrates respect, maintaining encounter calmness. After delivering the documentation, both hands return to the steering wheel, visible, remaining calm. Phrase 3. I refuse consent for searches. Your third crucial statement protects your firearm, your vehicle, and your liberty. I refuse consent for searches. Here's the scenario. The officer possesses your documents. They've verified your information. Now they're investigating. Where's your destination? You're not transporting anything illegal inside the car, correct? Most individuals respond negatively. Then the officer states, well, when there's nothing illegal, you shouldn't object to me conducting a brief inspection, correct? That's entrapment. They lack probable cause. If possessed, they'd already be searching. Through asking, they want you surrendering your Fourth Amendment protections. Once you consent, they can thoroughly inspect your vehicle, and anything discovered, even lawful items appearing unusual, can justify arrest. For firearm owners, this proves deadly. A magazine lawful here, but prohibited nearby. Ammunition stored incorrectly. A blade that's acceptable in your region, but a weapons violation elsewhere. Even when everything remains legal, the search prolongs the stop, increases tension, and creates misunderstandings. Within some jurisdictions, when they discover any firearm-related item they claim violates a local regulation you never encountered, you face illegal possession charges, ranging from significant misdemeanors to felonies with incarceration. I've witnessed authorizations revoked because a consensual search revealed a handgun positioned under a napkin rather than a secured container. Therefore, here's your third phrase. State it precisely. I refuse consent for searches. Not no, not I suppose, not yeah, whatever. Ambiguity equals consent within courtrooms. When they press, why not? What's being hidden? Repeat. I refuse consent for searches. Don't elaborate. Don't rationalize. Don't become defensive. This returns the burden to them. Obtain a warrant or establish genuine probable cause. Usually they won't, and the encounter concludes. But when they detain you 20, 30, 40 minutes while awaiting backup or conducting additional checks, you require the fourth phrase. Phrase 4. Am I permitted to depart? This question protects you from unlawful detention. Once the citation or warning is issued, the traffic stop legally terminates. According to Rodriguez v. United States, any prolongation beyond the time frame necessary for the original infraction becomes an illegal seizure unless the officer possesses reasonable suspicion of additional crime. Yet, most officers won't inform you your permitted departure. They'll continue conversing, hoping you'll make mistakes. For firearm owners, additional minutes equal additional jeopardy. You might nervously mention your pistol, or they might notice a shooting range bag, providing them justification to investigate further. When you remain past the lawful conclusion, and they eventually claim suspicion based on your own responses, they can search, pat you down, even arrest you. I've observed lawful carriers detained for extended periods, talking themselves into charges from illegal possession to criminal intent, entirely because they never questioned whether they could depart. Therefore, here's your fourth phrase. Officer, am I permitted to depart? This forces a legal determination, either affirmative, collect your documents and leave, or they must articulate specific facts justifying detention. When they state, "Just several more minutes," politely repeat, "I understand. However, am I being detained or am I permitted to depart?" This becomes your exit strategy. When they hold you without genuine suspicion, evidence found subsequently can be excluded. And most officers won't risk that on recording. Additional phrase: when they do detain you, no, you cannot depart, and begin demanding answers immediately. State, "I'm going to exercise silence and I request a lawyer." Then stop talking. Every word afterward can destroy you. Maintain silence. Wait for counsel. Allow the attorney to handle it. Quick summary. 1. "I don't know, officer." Protects you from guilt admissions. 2. "My license is inside my wallet. I'm retrieving it presently." Prevents suspicious movement allegations. 3. "I refuse consent for searches." Shields your Fourth Amendment protections. 4. "Am I permitted to depart?" Ends unlawful detentions. Any single mistake, speaking excessively, moving without narration, consenting to searches, or remaining past the lawful conclusion can cost thousands, your authorization, or your liberty. Memorize the 4 phrases, rehearse them, and carry with assurance. Press that like button and help Wines of Thought reach our incredible milestone. Every single viewer matters. Your engagement is what powers this mission forward.